a time or two. And candidly, in fact, I believe all of the things I've ever appeared on were termination of parental rights cases. Sometimes when I stand before this tribunal, I begin to wonder if most of my arguments don't belong in a different forum. What I mean by that is we see every year that the legislatures continue to erode away parental rights, begin to erode away the ability for parents to not end up in termination the way they are. And it just, in my opinion, some of those things are just simply out of this court's control, and I recognize that. However, there is a 2002 court case in RE Valentine. I'm sure the court's very familiar with it. I don't have to cite it. But that case defines something called clear and convincing evidence. And that case defines clear and convincing evidence as being evidence in which there is no serious or substantial doubt about the correctness of the conclusions drawn by the evidence. Okay? I'll be honest with you, in practice, I don't know what that means. But nonetheless, it's there. And I would invite this court to give substance to that definition of clear and convincing evidence. Because what we have, in my humble opinion, what we have is we're losing sight of clear and convincing evidence, and we're, as a result of that, surrendering too many of our children into termination. Okay. Addressing the actual aspects of this case, this court went to trial, or this case went to trial. The court found two grounds upon which to terminate against my client, who is the mother. And those two grounds were failure to manifest an ability and willingness to assume custody or financial responsibility of the children. And the second ground was one for failure to pay child support. Okay. When addressing the first of those two grounds, let me say this. The evidence is clear. Mother lived in Kentucky. The children were living in Kentucky. Several allegations against the mother had been made in Kentucky. Several DCS reports had been investigated in Kentucky. Yet Kentucky never removed the children from the mother, ever. The father takes the children, brings them down here to Tennessee. Referrals made. Tennessee DCS gets involved, and Tennessee DCS pulls the children out of the home of the father for reasons that are found in the petition, reasons found in the court action. Yet none of those allegations were against the mother. We have a situation that there were no clear and convincing evidence grounds to take the children away from the mother, yet we find no ability to return the children to the mother. In my opinion, again, that's a miscarriage of justice. In fact, as it relates to the mother herself, she currently has a child in her custody in Kentucky that has never been removed from her care. The DCS in Kentucky never thought it was appropriate to remove the children from her, or the children or the child, either which. That being said, the allegations are pretty significant, and I won't sugarcoat my client. My client has a lot of issues that the court has read about or will read about. The problem is those issues that the mother has are the same issues that affect pretty much every single parent family. You know, her problems are no different than what affect probably 30 or 40% of the children or the parents trying to raise children today. She's poor, she's broke, she can't afford anything. You know, her housing's unstable. The court's gonna find all that to be in the record. You know, but again, the problem is with all those deficiencies, she was never found to be not good enough.
Did she fail a drug screen a few months before the termination petition was filed?
She did, Your Honor. Everything, and again, admits to smoking marijuana.
I'm sorry, what?
Admits to smoking marijuana.
Okay.
Okay, so all her failed drug screens were marijuana related.
And so, under Kentucky law, did she have a valid prescription for use of medical marijuana?
I do not believe she did, quite candidly. I don't know that that issue came up, but to be quite honest with the court, she probably would not have had one, because that would have required her to go to a medical doctor to get it.
And so what were her diagnoses that she was medicating with marijuana for? What conditions was she seeking that?
She had several. She had PSTD. I think I said that right. She had borderline personality disorder. She had psychotic episodes herself. And I would suggest she was self-medicating. There's no question about that.
So, and were those conditions diagnosed? Did she, there wasn't any proof from a doctor here about what she was suffering? This was all?
No, I think those were actual diagnoses out of Kentucky. I don't know that they ever made their way into the record in Tennessee. But I think she testified to all of them, and that she was actually in therapy at the time as well. So, and trying to establish that she had failed to manifest, one of the issues was that the children reported that they were concerned, that they were fearful, that they didn't, that there were issues in the home. But when the actual evidence came out as to what those issues were, none of them were related to her home. They were all related to the home in Tennessee, except for one, and I say one of the children reported that she had left her alone in a hotel room once. Mother testified, the only evidence we have of this, mother testified, I went outside and smoked a joint. Now, I'm not trying to defend that, but that's the evidence that was presented. That's the only time, of all the children's fearfulness, that's the only thing you could attribute to mother.
On the second ground here, the failure support, I mean, to me, that is sort of either you have supported or you have not. And it's like many of the grounds in the statute, it's very binary. You either tick that ground or you do not tick that ground, and support is one of those. Now, I appreciate the argument you've made here, namely that, well, there was cost incurred to travel Kentucky, but in my research, I've never found a case where we've credited that as support. Are you aware of a case where we've used something like travel expenses as support as opposed to some sort of gift to the children?
No, the argument there, and doesn't look like I'm going to be able to get to clear and convincing, or I'm sorry, to best evidence, but the argument there is very simple. I mean, DCS spends tens of millions of dollars a year. They couldn't give the mom $100 to get to Tennessee to visit her children, even though they're required by law to effectuate visitation. They're required by law to make that visitation happen. Yes, this court has determined that there can be child support in kind. It has never ruled that in kind would also include mileage to get down to Tennessee to visit your kids. But let me wrap up by just saying one thing about the best interest argument. As this court knows, there are now 20 best interest issues that we can discuss. But fortunately, the legislature did leave one opening. It allows this court to consider things beyond those 20 issues that they present. Not a single one of those 20 issues, or not a single one of those 20 considerations, does the court say that you should consider keeping the family together. Not a single one of those best interest arguments say, let's look at cousins and uncles and aunts and moms and dads, and we're destroying families. And I would ask this court to exercise its ability, under clear and convincing, to overturn the termination.
Thank you, counsel. We'll hear from you, ma'am. And you represent the father.
I do. I'm Susan Harmon.
Pull the microphone down a little bit.
Is that better?
Thank you.
Excuse me. Of course, it's time to cough. I'm attorney Susan Harmon. I'm a member of the Sevier County Bar, and yes, I am here on behalf of Zachary Bentley, the children's father. The first issue that we were discussing was the failure to manifest the ability to assume custody, and that appears to focus on lifestyle and circumstance. I feel that at the TPR hearing, the father proved he had stable, appropriate housing for the children prior to the actual filing of the TPR, and it even remains in place today. The home was deemed appropriate by the previous guardian ad litem, though the current one never went out to investigate it. It was also shown at this hearing father maintained stable employment from the inception of the case through the TPR hearing, and his employment situation has only improved over time. And the criminal issues which brought everyone to where we are today were resolved, and they were actually dismissed. So he did a very good job there of putting stability back into his life. Regards to the substantial harm to the physical and psychological welfare of the children, that it must be more than theoretical. DCS testified to the disclosures that the children made regarding punishment, but didn't offer any testimony or evidence regarding what a therapist thought about it. There was a suspension of visits for a short period of time, but DCS wasn't willing to put forth a therapist to testify that it was in their best interest. Excuse me. So there was no indication that the children shouldn't be around their father or their stepmother, where some of these allegations had arisen. Even 18 months into the case, DCS was still talking about a need for an increase in therapeutic level for the children, but didn't do anything with it. And the foster mom even testified at court that the same behaviors that the children had when she first had them, brought them in, were still evident. So being in a different environment did not change the children's behaviors, and there was no evidence to prove substantial harm was more likely to occur if returned to the father. Unfortunately, with the failure to pay child support, we can't dispute the fact that no payment was made prior to the TPR filing. However, because I was there at the DNN hearing, a request was made by both counsels, both attorneys here, that the child support be waived, and it was granted by the judge. Unfortunately, the language did not make it into the order, and father wasn't present for child support. I don't believe I ever got a notice regarding it either. When we leave court in Sevier County, unfortunately, there's a lot of hurry up and get everybody out and move somebody else in, and so it obviously did not get noticed in the order that was written up. But my client relied on that to his detriment. He heard what the judge said.
We're pretty much limited by what's in the record.
I understand, but we did mention it at court that, you know, the judge had said that, and but obviously it didn't make it to the order, and we understand that. I believe he makes child support payments now, which I know too little, too late, but this is how he has evolved. And this goes to the best interest of the children. DCS provided him with a list of things to do, and he has done them. And he was in substantial compliance by the time that we reached the TPR hearing, and has followed through even now, continuing to do some of those things.
But isn't part of the concern here with father his current spouse, though?
It is, but again, there was nothing from a therapeutic standpoint that addressed that. DCS talked about it, but they didn't follow through with any expert testimony to indicate that she really was a problem.
Well, let's leave aside father's spouse for a moment. What's disturbing to me, though, is the circumstances under which the children came into father's care in July of 2021. That is described in various places in the record as a kidnapping. I mean, what did the proof show with respect to that incident at I think it was a Walmart?
I think the proof showed just the testimony of mom was that he just swooped in and picked the children up. I believe that DCS testified that, you know, the children were being removed by Kentucky DCS, and that was certainly the testimony of my client, was that he got a call from Kentucky DCS to come get the children. his custodial arrangement with the mother was that if she ever felt she couldn't take care of the children, he could have them while she addressed whatever issues, but he couldn't just go get the children. And additionally, there was a character witness for the father who testified that when he would see the children with the father, they were well behaved and not afraid of their father or their stepmother. And, so we don't have anything to go on regarding the stepmother because, again, DCS didn't provide any therapeutic information other than just disclosures from a case manager and the foster mom. And father always provided for the children when they were in his care, but they would be removed actually by the biological mother at a moment's notice. Because he didn't have any specific court-ordered time, he could have time with them, but it wasn't set like in a parenting plan. And there's no evidence. He maintained visits with the children in as much as DCS allowed. There was some communication issues along the way, and sometimes visits didn't occur, which was very frustrating to him, and he did have words with DCS a time or two about that. There was no evidence that presented that showed the children's attachment to the foster mom affected their relationship with the father negatively. I have to point this out to the court, though. These children, in this case, have 3 other half-siblings, and had Dad been allowed to put these 3 children with his other 2, who are currently with his wife's in-laws, foster care approved, we wouldn't be here today on this. No, DCS wouldn't have been proceeding with a TPR.
Excuse me for interrupting. Did
Certainly.
the trial court make specific findings with regard to what you've just articulated?
Actually, I do not recall. I apologize for that. I know that there was talk of the foster parent, the in-laws who were foster parents, who had custody of his other 2 children, but I'm not 100% how much we delved into it. I was just pointing that out that, looking at this particular issue for best interest, these children are all now split up. And of course, mom has her own child who is a half sibling as well with her in Kentucky. I have to say for my client, just very quickly, he took advantage of all the services offered by DCS. He realized mistakes had been made and he needed to change his life, and he was very insistent on doing that and has continued with it. I saw the change in him myself, and was in substantial compliance and working to do better at all times, including, his mental health evaluation. There was some issue with that, but he sought mental health counseling through these programs. He paid for his own batter's intervention and that of his wife. It slowed down some of his progress. So I would ask that you all please consider remanding this back to the court for further hearing. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court, Mara Cunningham with the Tennessee Attorney General's Office, here on behalf of the Department of Children's Services, defending the Sevier County juvenile court order terminating parents' parental rights. We are here today with the goal of establishing permanency for 3 children under the age of 10 who, prior to coming into foster care, suffered constant abuse and neglect and had never known stability. This court should affirm the termination of parents' parental rights because the department proved with clear and convincing evidence that grounds existed to terminate parents' parental rights, and the termination was in the children's best interest. First, regarding the grounds for termination, parents failed to manifest an ability and willingness to care for the children and failed to abandon the children by failing to provide child support. First, as to failure to manifest, neither parent had the ability to care for the children. Both parents did complete psychological evaluations, and this evaluation determined that neither parent was credible in their self-reporting and found that neither one had minimal insight into their conditions and had a limited support network.
What was did the trial court make specific findings as first as to the mother and then as to the father, as to the failure to manifest an ability.
Yes, the trial court found that neither parent lacked the ability to care for the children.
I understand that's the conclusion, but did the trial court make any findings saying, here's why I find that they are not able, that they do not manifest this ability?
Yes, Your Honor. It focused on the parent's instability throughout the case, mother's substance abuse, father's domestic violence, and his criminal history, as well as their mental health concerns. For the mental health concerns, it was the psychological evaluation concluded that their non-credible self-reporting combined with their defensiveness throughout the assessment and the children's regressive behaviors after visits led to the conclusion that the prognosis for effective parenting was considered very low and reunification would likely be unsuccessful.
Excuse me for interrupting. Did the trial court make specific credibility determinations?
So they didn't make explicit credibility findings. We did argue that he made implicit credibility findings of the foster mother and DCS, as well as father's minor sister who testified at trial and was in the care of father and was witness to much of the abuse that was disclosed to the children. She corroborated most of the children's disclosures about the abuse and also testified as to suffering abuse herself from father and father's wife. She also testified about the incident that led to the removal of the children, which was the fight between father's mother, father, his cousin, and his sister after his sister witnessed him punishing the middle child. And that ultimately led to father and his wife's arrest, as well as his cousin, and was charged with aggravated assault. That charge was ultimately dismissed. So father, in his psychological evaluation, failed to disclose any abuse allegations made against him, which the children made significant abuse allegations against him, and mother also made abuse allegations against him that he perpetrated on her. He also remained married to his wife, who was the main source of the children's fear, and also tried to incorporate his wife into the visits with the children, despite DCS telling him not to do so. He claimed to not know about any abuse that his wife perpetrated against the children. However, in one visit, the children asked him how they could be sure that she would not hurt him anymore, to which he responded that she was better now and that it wouldn't happen again. Father also claimed to have consistent employment throughout the case. However, he failed to provide any support to the children other than a couple of gifts at visits. Specifically as to mother, she was diagnosed with bipolar disorder with psychotic features, post-traumatic stress disorder with dissociative traits and panic attacks, and cannabis use disorder. At the time of trial, she was still trying to figure out the correct dosage for her psychotropic medications and instead was relying on marijuana to self-medicate. Now, the children were initially removed from mother's care and were in the care of their godmother, which is how father was able to take the children into his custody. And it was after about a month in his custody that the children were removed into DCS custody. However, mother minimized her role in the children being in foster care and made visitations seem better than they were in her evaluation. Mother also made zero effort to quit smoking marijuana, despite that being the reason that father was able to obtain custody of the children, and tested positive 2 days prior to coming into 2 days before trial, and admitted to smoking consistently throughout the case and smoking consistently while the children were in her care. Mother also did not have stable housing. From 2019 through trial in February of 2024, she moved over 8 times in various states and cities, moving into the homes of various family members or boyfriends or into government-assisted living. And she also often left the children with her sister-in-law, who had, at one point, had 12 kids in the home residing with her. Placing the children back into parents' care would pose a substantial risk of harm. Father's counsel argues that there was no expert testimony about this. However, this court has consistently held that no such expert testimony is needed for this ground. And rather, if you look at the recent history of substance abuse, mental health issues, and parents' significant history of domestic violence, case law has supported that this is sufficient to make a finding of substantial risk of harm. The children made significant abuse disclosures and actively expressed fear of returning to parents, both parents. The son had to physically be forced into the car to go into visits because he did not want to go. While father argues that there was no progress made while in foster care, upon removal, the children were described as feral. They were extremely violent towards themselves and one another. They did not know how to properly eat or use utensils. It was described that they covered their plates like prisoners and stuffed food into their mouth. This was likely because there were disclosures of father shoving food down their throats until they would vomit, gag, and could not breathe, and they would also be withheld food. Foster mother had to work with them to teach them to reinforce that they had food available to them. They would play violent games like Slice, where they would try to stab each other with various objects, and a game called Katie, which is the name of father's wife, where they would beat each other with belts and ropes. The children also the son had extreme night terrors, and the other children were wet the bed. With the help of therapy and foster mother's care, the children were taught that they were important. They learned how to self-regulate and were no longer violent or self-harmed except after visits, when these behaviors regressed. After visits, the children once again became violent, experienced night terrors, and wet the bed. In order for the therapist to see how the visits affected the children, visitation was suspended, and with the suspension of visitation, the regressive behavior stopped and the children were able to self-regulate. Once the visits resumed, so too did this regression. Case law has supported that these regressive behaviors and their active fear supports a finding that there is a substantial risk of harm to return the children to parents' care. For failure to support, neither parent made any payments during the relevant 4-month time period.
Is there anything in the record indicating that they were excused from making any child support payments?
No, Your Honor. Exhibit 12 is the preliminary hearing order, and that there is a mention of the possibility of the child support being waived. However, that box was not checked. Instead, the box was checked where it set a child support hearing, and that actually provided the time and date and location of the child support hearing, providing father notice. Father and his attorney signed this order and approved it. So there is nothing to support that other than father's testimony that this was waived. Mother actually testified that she remembered at the preliminary hearing them setting the child support hearing. So no, there is nothing to support a waiver of any child support. And additionally, father made 0 child support payments the entirety of the case. Mother did make 3 payments. However, this was after the termination petition was filed, which does not remedy this for this ground. As for the in-kind argument, in-kind support argument, mother's child support payments already had a downward deviation to account for the child support costs. And also, this court has consistently separated the issues between further downward deviations for travel costs and child support. So that's a separate issue. It also would not constitute in-kind support because it does not go to the care of the child. So the daily care of the child would be such as medication, school supplies, food, clothing, that sort of thing, not traveling to attend a visit. This argument should also be waived as it was not made at trial. This is a new theory on appeal. Therefore, DCS did not have the opportunity to respond to it. Instead, at trial, mother's argument was that she did not know how to make the payments. All right. To preserve time, the state will rely on its brief for best interest analysis. Other than to address that there was no evaluation as to keeping the family together, there are two factors, B and I, that account, or I'm sorry, not B, involving the child's relationship with parent, which is factor D, and I, which is the child's relationship with others, including biological siblings. In the trial court found that all factors weighed in favor of termination, so this was clearly considered. If there are no further questions, to conclude, the state would ask that this court affirm the termination of parents' parental rights. Thank you.
Our thanks to counsel, both sides. We appreciate your briefs and your oral arguments this morning in this case.
Thank you, Your Honor.